Good morning. Are you William Mallett?
Yes, ma'am.
And so Mr. Mallett was previously in court, entered a plea of guilty to obstruction or retaliation. Before we go forward, I got a pre-sentence report done and I've reviewed that. What's the status of, it shows there's a pending criminal mischief and evading arrest or detention?
So those should be under the misdemeanor.
Okay.
Cases that he does still have pending, so those be taken care of in misdemeanor court.
Okay, that's what I thought. I just wanted
Yes,
to
ma'am.
make sure we weren't looking at something else. Okay.
As far as I
So-
know, we don't have any other felony charges.
No reason not to go forward with sentencing.
Correct, Judge.
And so have both of you had an opportunity to review the pre-sentence report?
Yes,
We
Your
have,
Honor.
yes, Your Honor.
All right, any additions or corrections?
No, Your Honor.
Judge, just more of a suggestion. And I just want to make sure that his mental health issues are addressed in probation. I think
Yes.
that's going to happen. I just want to make sure I put that out there.
I will. Thank you so much for pointing it out again also. Mr. Mallett, I'm going to find that you entered your plea of guilty previously freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 4 years. You're ordered to pay a $300 fine and to follow all of the rules and conditions of probation. I am going to recommend that Mr. Mallett be at least, it looks like it's already the recommendation that he's on the high need caseload with Spindletop. And so we're going to get you whatever help you need to be able to be successful. But it's important that you take advantage of that, okay? So if you have appointments, you have to go to them. If medicine is recommended, you need to take medicine. Whatever it is to make you able to be successful on this probation, we're going to give you those tools through probation, but you have to ask for those things, okay? Do you understand?
Yeah.
Okay,
Yes, ma'am.
all right. And so if you do everything that you're supposed to on this probation, then this is a great opportunity because you don't have a felony conviction. At the end of the probation period, if you're successful, the case will be dismissed. You'll never be a felony, have a conviction on your record. The other side of that, though, is if you do violate any condition of probation, you can be brought back into court. You could be found guilty of the offense, and you could go to prison for between 2 years and up to 10 years. Do you understand?
Yes, ma'am.
All right, I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. If you'll just go back with the bailiff probation, we'll talk to you today to give you your instructions so that you know what to do when you're released from jail, okay? And then I don't know if he has bonded out on those. Maybe you guys can request that he get those taken care of this on their. This is Mr. Coleman.
Yes, Judge.
Buckle up, guys. Today we are stepping inside a courtroom where one decision can change a life forever. William Mallett stands before the judge after pleading guilty to obstruction, with pending misdemeanors still looming. The court weighs his mental health, his past, and his future, then offers a chance few ever receive, 4 years of probation instead of a felony conviction. But that opportunity comes with strict rules, real consequences, and a warning that one mistake could send him to prison.
He doesn't have to participate if you don't want him to.
Good morning, sir. Are you Vishal?
Yes, ma'am.
And this is cause number 25 DCCR 0507. Mr. Vishal was previously in court, entered a plea of guilty to the state jail felony offense of criminally negligent homicide. This was unagreed. The plea was, I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Judge.
State has, Judge.
Are there any additions or corrections to the report?
Not from us, Judge.
Not from the state, Judge.
All right, then, Mr. Gertz, you may proceed.
Judge, we're asking the court to consider probation. This case is unique, I would argue, for a variety of reasons. First and foremost, this court is very familiar with me and my proclivities. I would try this case 100 times out of 100. When I walked in to talk to him the first time, he said, I want to accept responsibility. That almost never happens. He didn't shirk his responsibility. We can talk all day about the fog. We can talk about the Tex dot needs to get their act together with the shoulders on the highway, whatever we want to talk about. He wanted to take responsibility. And he said it from the first day. When was the last time you ever saw me come in and plead on the first hearing, plead guilty to a serious offense like this? Never. He wanted to do that. That was him wanting to do that. And so from that standpoint, it's a unique case. The other reason it's a unique case is there's no aggravating factors here. He's not intoxicated, he's not on his phone, he's not doing anything other than driving his vehicle. Now, what happened to these people in the end result is absolutely tragic. And again, he's taking full responsibility for that. But I will tell you, Judge, if he'd had 5 more seconds notice, he wouldn't have been able to stop the vehicle. It had 10 more seconds notice. He wouldn't have been able to stop the vehicle. He's doing the speed limit. He's driving on the highway, and there are vehicles on his left and behind him, and there is a stopped vehicle on the interstate. I mean, there's not a scenario in which maybe the injuries are less, but there's not a scenario in which this accident does not happen. And so, again, he's saying, I should have been more careful, I could have done other things, I could have fixed this. And the way he's saying that is with his plea, and also his statements here. He expresses deep remorse, he struggles to sleep at night, he feels guilty about what happened to these people. And again, there's nothing redeeming about the outcome for these decedents, these victims. But the reality is, this is a situation that is a terrible, tragic accident. He is trying to take responsibility. I think that is, again, at least from my standpoint, is somewhat unique. And I'm asking the court to at least consider the distinct possibility and the option here that you have to grant him deferred adjudication probation. He would give up his driver's license, he'll give up his CDL, he'll do whatever the court orders in order to comply with probation. But putting him in the state jail for, another year and a half is not going to fix anything. It's not going to make it any better for these decedents. It's not going to make it any better for their families. It's not going to do anything to anyone other than just cause him to not be out in the world for a year and a half, and that's it. And so this court could supervise him, this court could oversee his continued acceptance of responsibility, and also protect the public at the same time.
The courtroom shifts as Shaw appears, facing a state jail felony for criminally negligent homicide. His attorney argues that this was a tragic accident, not reckless behavior, stressing that the defendant accepted responsibility immediately and showed deep remorse. He describes the crash as unavoidable, pleading for probation rather than prison. Every word builds toward a single question hanging in the room: is mercy possible when a life has been lost?
So we're asking the court to consider doing that, and that is our request.
All right, thank you. Mr. Coleman?
Thank you. I'll be brief.
I'm sorry. Are there any holds? No.
I'll be
Go
brief,
ahead.
Judge. Mr. Gertz and I agree on one thing, that I, like him, would try this case up, as he puts it, 100 out of 100 times. Myself, Judge, this is no accident. This is pure negligence, as it is the definition of negligence. I'll spare the court. I didn't showing the court the video. The tractor trailer that this defendant was operating today was equipped with dash cam, or a version of dash cam video that shows that the vehicle that he struck was not stopped. It was traveling at a slower speed with its hazard lights on, but it wasn't stopped. There was no fog, the conditions were clear, and there was no cars on the other side of this tractor trailer rig, preventing it from even changing lanes. I have the video. The court, if it desires, can certainly watch the videos. Short clip. But Judge, I take issue with that recitation of how this all went down. I'd like to offer State's Exhibit 1. It's a certified copy of FBI records indicating that
Make
this
that
defendant...
2.
Make it 2?
Because States 1 would have been the plea papers.
All right.
And we have no objection to it.
It indicates, Judge, that this defendant illegally entered this country and he's a national of the country of India. Judge, I'm not here to make some type of a political statement or commentary. I'm just simply saying that it is a violation of federal law to enter this country illegally. And Judge, like any other violation of law, in any other case, you can take that into consideration in sentencing this defendant. I'm asking you to take that into consideration in this case, Judge. So here's states 2.
No objection. States 2 is admitted.
Judge, I also offer states exhibit number 3 pursuant to a business record affidavit that's been on file. It is a photo of the victim in this case, Judge. 16-year-old victim in the short obituary of her young.
No objection.
States 3 is admitted.
Judge, she was 16 years old, Judge. She had, at the dawn of her life, she'll never get to graduate high school, get married, do the things that people do. Judge, you can say today by your verdict just the amount of damage and harm this defendant has caused due to his negligence. I'll conclude with a couple other things, Judge. This defendant went on to continue to live his life as business as usual in California after this accident while the investigation played out. After the investigation and the indictment, it took some effort on the part of our office in conjunction with the U.S. Marshal's office to track down and locate this defendant. I'm not saying he was intentionally hiding or absconding. I'm simply saying it took a lot of effort by federal law enforcement authorities to track him down, Judge. And also this business about this name and the alias name and whether or not he goes by no name given or goes by Bishaw. Again, the court can infer whatever the court wants to infer about why an individual would illegally enter this country and use at least one or maybe 2 different aliases, Judge. I'm asking for the max, and I am frustrated at the fact that all I can ask for is 2 years in this case, Judge. But I'm asking for the 2 years. In this case, I think this case warrants 2 years. Judge, if the court is not inclined to give it 2 years, I'm asking that the court deny the discretionary jail credit pursuant to my motion that I file under Article 42A559 of the Texas Code of Criminal Procedure, Judge. And lastly, the family.
Say what you just said again?
It's in my motion that I filed, asking that the court deny the discretionary jail credit for state jail offenses.
Oh, okay.
It's 42A559C of the Code of Criminal Procedure, Judge.
Okay.
And lastly, Your Honor, the family's here for whatever, for what that's worth, Judge. And I believe that the mother of the deceased would like to make a victim impact statement.
Thank you, Mr. Coleman. So it's my understanding that there is, at this point, an immigration hold on Mr. Bishaw, correct?
Yeah, that's my understanding too, Judge.
Okay.
The prosecution strikes back, calling the crash pure negligence and challenging every detail of the defense's story. Video evidence, immigration records, and a photo of the young victim are presented to the court. The weight of the loss is laid bare as the state demands the maximum sentence. The tension rises as the judge listens, knowing the decision will define justice for the family and the fate of the man standing before her.
So even though it's likely for him to be deported because he's here unlawful, you're asking for probation?
Well, Judge, there's not really another option, right? So I guess the question is, given the current status of our immigration situation, I have no idea how ICE is going to handle this. What an ICE hold means is that if you give him probation, they've got 3 days to come pick him up. And if they don't come pick him up, then he's placed on probation. And what the court can then do is supervise him unless and until the federal government comes and deports him or attempts to deport him. The kind of alternative to that is he can sit and sleep on a cot that we're providing and, eat food that we're providing, and then be deported at the end of that. With a conviction or a deferred adjudication, he's going to get deported at some point anyway. So it doesn't really, the court, I'm not trying to be difficult, but this court's decision is not going to change the likelihood of his deportation, because a deferred will count as a conviction for deportation purposes. A conviction will count as a conviction for deportation purposes. So, again, we're asking the court for probation because of his acceptance, again, of responsibility here in this case.
All right. And I appreciate the acceptance of responsibility. I do. I appreciate, and I'm sure the family appreciates, not having to go through a trial and see what they had to live through over again. And so I will take that into consideration. Probation, to me, in a felony case, really of any kind, when someone is here unlawfully, doesn't make any sense. And again, I'm with Mr. Coleman. I'm not here to make a political statement on any of this, but if you're here unlawful and you've committed a felony offense, it just doesn't make sense that I would put somebody on probation where they're potentially still a, I don't know, threat to the safety of our citizens. And the no-name thing gives me some concern. Also, I feel like that is just potentially an attempt to avoid probably some issues with immigration and some issues with potentially this case. So what I'm going to do, again, I appreciate, and I'm sure the family appreciates, not having to go to trial. But I'm going to find that you entered your plea of guilty freely and voluntarily, find sufficient evidence to find you guilty, and at this time find you guilty of criminally negligent homicide, sentence you to a term of 20 months in the state jail prison. You will receive, I will give credit on that for any time that you've been in custody that the law gives you the right to receive. With regard to the state jail credit, I leave that up to the state jail authorities, and I'm going to deny the motion to deny that credit. That will be up to Mr. Vishaw in state jail. With good behavior, he'll get that credit just like everybody else. So I'm not going to deny that. It's based on, always has been based on how you behave in the state jail prison. And so just to deny that, it goes against the nature of that rule and that law, so I'm not going to do that. I'm going to hand you the trial court certification that shows there was no agreement, which means you do have a right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that to determine what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Gertz. Good luck to you, sir. Thank you, Mr. Coleman, Mr. Gertz. Okay, did Ms. DeLage?
Yes, there was a
The judge questions the impact of immigration status and the meaning of probation in a felony case. After acknowledging the defendant's plea and the family's pain, she delivers the verdict, guilty, with a 20-month state jail sentence. She allows credit for time served and explains the loss of firearm rights, making it clear that this judgment is final and life-altering. The courtroom absorbs the reality of a life reshaped by a single ruling.
Oh, I'm sorry. Yes. If y'all will have a seat, Mr. Kimler, can you move for a second so they can use that table? You can just have a seat over here and we'll go off the record for the victim impact statement. Good morning. Are you Dakota Kuhn? And Mr. Lewis, will your client waive the formal reading of the motion?
He does, yeah.
Mr. Kuhn, in cause number 23, DCCR 0968, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation March 1st of 2024 for the lesser offense of attempted assault on a family member by impeding breath or circulation, state jail felony, and that was a 2-year deferred probation. Is that correct?
Sure.
And then count 1 alleges that you violated your probation. It alleges that you committed the new offense of possession of a controlled substance, May 12th of 2025 in Chambers County, Texas. And is that true or not true?
True.
Count 2 alleges that you violated your probation by possessing a drug, cocaine, at the time of that arrest on May 12th in Chambers County. Is that true or not true?
True.
Count 3 alleges that you failed to never become intoxicated in that you provided a urine sample April 30th of 2025 that tested positive for cocaine. Is that true or not true?
True.
Count 3 alleges that you provided a urine sample May 9th of 2025 that tested positive for cocaine. Is that true or not true?
True.
Count 5 alleges that you provided a urine sample May 21st of 2025 that tested positive for cocaine. Is that true or not true?
Sure. Judge, if that's enough, we can.
Sure, the state abandoned 6, 7, and 8. Did you enter your pleas of true to counts 1 through 5 freely and voluntarily? Okay, and did you plead true to those counts because they're actually true? I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection, Judge.
It's admitted. Is there any evidence that Mr. Kuhn is not competent?
No, Judge.
All right, sir, I'm going to find that you entered your pleas of true to counts 1 through 5 freely and voluntarily. Find those counts true. Find sufficient evidence to find you guilty, and at this time find you guilty of attempted assault on a family member by impeding breath or circulation. Sentence you in accordance with your agreement. Sorry, my tablet just got to a term of
15.
15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm going to hand you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I'm also going to hand you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. You should read that written admonishment to see what devices qualify as a firearm or ammunition. Also, if you have any questions about how long that lasts or any of those laws, you can talk to Mr. Lewis. All right, good luck to you, sir. You can go back with the bailiff. I was going to try to shorten it. That didn't work. I need to write out what I want to say. I did it once right today, and that was it. Just too many words.
A new defendant faces the court as a motion to revoke probation is read aloud. One by one, violations are confirmed, including repeated cocaine use and a new drug offense. With each admission, the outcome becomes inevitable. The judge accepts the pleas, revokes probation, and sentences him to 15 months in state jail. Another chance disappears, reminding everyone how quickly freedom can slip away. Like the video, subscribe to the channel, and we'll see you in the next video.